all right.
Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all.
Morning. I have 3 issues left to deal with, and I don't intend to be all that long, I hope. First is a few words about Canada's proposed 1% holdback for a group of individuals claiming to be a First Nation band who may or may not become entitled. I understand the group of 7 is going to be dealing with this in more detail, but my submissions are going to be very brief.
I was just checking over my shoulder to see if Mr. Greenberg was signed in today.
Ah.
Yes, no?
Yes, he's on.
Okay, super.
All right.
Thank you.
There we go. The intervention order at section paragraph 2Q, as in Queen, was clear that the intervener, Name Gusisagagan, cannot make any submissions or lead evidence in conflict with the position taken by the original plaintiffs on the issue of distribution. Their submissions seek to do just that. They should just be ignored. Canada could lead evidence and could make submissions challenging the distribution method that the plaintiffs advocate for, but Canada did not lead any evidence to challenge the demographic evidence of Dr. Bignami or Dr. Dribbin on populations or the cohort of people in that population group. I observe that the arguments that the NAME group asks the court to consider includes in reference to alleged facts, which are not in evidence, not tested in cross-examination. I would ask the court that those references in their argument should simply be ignored and should not be finding its way into any reasons. No doubt the NAME group wishes to advance grievances against the Crown, which they say for refusing to recognize NAME's existence. Now, if and when that is resolved, our position is that the Crown responsible for that neglect should be the entity responsible for any compensation properly due to that group, regardless of the outcome of this case.
Can you just remind me, do the I'm just looking at the notes of what you said.
Mm-hmm.
The plaintiffs do not propose any holdback for NAME, is that correct?
That is correct. No, the plaintiffs do not think there should be any holdback at all. And there is no basis in the evidence for there to be any holdback.
Okay.
Canada led no evidence. NAME could not lead any evidence. They were prohibited.
So Canada proposes
Canada proposes a 1% holdback, but that has to be based on some evidence, and there isn't any evidence. It's that simple. And when I look at it from a fundamental justice point of view, I think to myself, well, wait a second, why should the plaintiffs in this case have to fund the wrong that Canada is alleged to have committed in respect of another group that is not a party to this litigation? If in fact the NAME group in the future is correct that they have been wronged, or if Canada admits that they have been wronged, that's Canada's responsibility, not the plaintiffs. That's my submission. Turning then to Crown liability, which Crown is liable.
Could you just
Yes.
take a moment to
Yes.
please? Okay, thank you. Go ahead.
Turning to Crown liability, which Crown is liable? Our position, of course, is that liability is joint and several. At paragraph 57 of their reply argument, Ontario posits that liability for pre-Confederation liabilities is a matter of the division of powers, is not a matter of the division of powers, but is rather governed by sections 111, 112, and 142 of the, what used to be called the BNA Act, now the Constitution Act 1867. Now, in support of that proposition, Ontario cites in their footnote paragraph 69 of their statement of defense as the authority for that proposition. Now, there's a few problems with their proposition. The first is the obvious one. Citing one's own pleadings is not a persuasive argument as to what the law is. Secondly, section 69 of their statement of defense does not, in fact, say what they now say it says in paragraph 57 of their reply argument, although I would concede one might fairly could infer that you could draw that kind of conclusion. Thirdly, their proposition assumes, incorrectly we say, that the post-1867 treaty obligations and the treaty obligations into the future for all time are pre-Confederation liabilities. We say that the proper characterization of what happens after 1967 to pay the augmentation is a present obligation based on revenues received or receivable. So for example, let's use the year 2010. Just chosen at random. 2010, only the amount of revenues to be shared or under the augmentation clause, that obligation only comes into existence in 2010 and is not a pre-Confederation liability at all. It doesn't become a pre-Confederation liability because the bargain, the treaty, the promise is rooted in an instrument that predates Confederation. The treaty bargain may be a pre-Confederation treaty, but that actually does not dictate or address which crown or both is liable directly to the Anishinaabe.
When you say the treaty bargain does not dictate?
No, I say the fact that the treaty bargain is a pre-Confederation treaty that happened before 1867 is not the determinative answer as to which crown or both is responsible for the obligation under the treaty.
So the timing of the treaty, you say the timing of the treaty is not determinative.
Right.
Of the creation of the liability.
That's correct. There are two things I think the most important determination, and I think the only one that matters, is that the law on direct liability under the treaty is not a function of section 109, section 111, 112, or 142. Those sections deal with respective liability as between the crowns. I believe that the proper understanding of the law was actually succinctly and clearly articulated by the Supreme Court of Canada in Grassy Narrows, that they were sufficiently clear that liability of the Crown is a function of jurisdictional capacity to honor and perform the treaty promise. Nothing less would uphold the honor of the Crown. And I'm just going to read from my submissions, main submissions, paragraph 294, where I just quote from 293 and 294, where I make reference to portions of the Grassy Narrows case. And you might remember at paragraph 30, Justice McLaughlin for the court says in part at paragraph 30, the level of government that exercises or performs the rights and obligations under the treaty is determined by the division of powers in the Constitution.
And you were looking at?
Page 137, paragraph 593.
No, but where in your submissions? In your reply or your?
No, in my main submissions. I apologize.
In your main submissions?
Paragraph 593. Sorry? I said 293? All right, again, I can't read my even printed writing. All right, paragraph 593. It's paragraph 30 of the Grassy Narrows. I bolded it in the text in my argument. The level of government that exercises or performs the rights and obligations under the treaty is determined by the division of powers in the Constitution. And over on the next page at paragraph 594, paragraph 35, McLaughlin concluded that the promises made in Treaty 3, which was an 1873 treaty, were promises of the Crown, not those of Canada. I'm going to pause there for a moment because recall that Ontario wasn't invited to that party in 1873. They took no part of it. They were not privy to it. Yet the Supreme Court of Canada in Grassy Narrows affixes them with liability under that bargain to which they were not a party. Why? Because even though Canada unilaterally entered into that treaty without consulting Ontario, without the agreement of Ontario, the promises were promises of the Crown. And
you said Ontario wasn't invited to the party in 1873.
Yeah, that's right. They took no part in Treaty 3.
Oh, in Treaty 3.
Yes.
Right.
Yes. The promises made in Treaty 3 were promises of the Crown, not those of Canada. Both levels of government are responsible for fulfilling those promises when acting within the division of powers under the Constitution Act 1867. That says it all, I think.
Is that also the foundation for your argument on joint and several?
Yes. Yes. The joint and several liability is each Crown is responsible based on their jurisdictional capacity under the Constitution Act to effect the promise. And because the treaty promise requires diligent and purposeful fulfillment, each Crown has to ask itself, what can I do within my power to effect this promise? Both of them have obligations to share information. And there really is only one annuity augmentation. There's not two annuity augmentations. There's not an annuity augmentation due from Ontario and a separate augmentation due from Canada. What is due is an augmentation from the Crown. Now that will require coordination between the Crowns. It's expected that there will be cooperation, but there is only one promise. And when it comes to the power or authority to pay, the spending power of the crowns is not at all affected by the division of powers by 9124. Both crowns have the jurisdictional capacity to make payment whether or not it is within a division of powers. And Hogg makes that clear, and I've cited that at the citation to that at my footnote 392 of page 139 of my main argument, paragraph 599 of the argument. So there's no jurisdictional promise. The other sort of important
Jurisdictional promise or no?
Sorry, no jurisdictional impediment to the promise. My apologies. The next important aspect of Crown liability, I want to jump to my paragraph 604, and it's a case by Justice Duncan and of the Yukon Supreme Court. I thought it was useful because I thought Justice Duncan, provided a useful summary of joint promises and joint and several promises. And she, over on page 141, she identifies a joint and several promise as follows from looking at the authorities. Joint and several liability arises where two or more persons join in making a promise to the same person, and at the same time, each of them individually makes the same promise to that same promisee. Now, let's go back to 1850, and you might remember that we actually had two entities involved at the time. Although in one sense, one can say that there's only one crown, we know from the 1982 Secretary of State case, which I don't know if I need to turn it up, Lord Denning of the United English Court of Appeal, he talks about, it used to be that one spoke of the crown as undivided, but the reality is we now have divided crowns. But what happened in 1850, you might remember, is that there was a provincial executive. And the provincial executive authorized the making of the treaty and ratified the treaty. But so did Lord Elgin, I believe it was, on behalf of the imperial crown. So to say who was the treaty with in 1850? Was it with the imperial crown? Well, the imperial crown had authority under, I guess, jurisdictional authority in respect of Indians up until 1860. But the provincial executive, the province of Canada, was actively involved in the agreement itself. So you have two crowns, really, two representatives. You have the imperial crown and the province of Canada joining together to make one promise.
Can you remind me what Lord Elgin did? I recall he was there. I recall there were discussions, but was there some formal ratification by Lord Elgin?
Yes, I believe on each of the instructions, Lord Elgin approved them. I can probably find
the instructions to Robinson.
Yes, I believe that to be the case, and we can try and track that down for you if it's. I don't have it in my argument.
And post treaty, was there some rule?
I don't recall anything in the evidence about a post-treaty ratification by the imperial crown. I recall that Lord Elgin was actually at the treaty talks, you might remember. And so the imperial crown representative actually participated in the process. So to call the imperial crown at that time a party would not be incorrect. To call the province of Canada a party would not be incorrect. So we have these two groups, whether there's a separate crown or not, you have two groups of people responsible to different masters, so to speak, who take part in an agreement where there's one promise, one augmentation annuity, and then we get into confederation. And you might recall, and maybe I should turn up to it, the 1982 case, R versus Secretary of State. Where the conclusion, Lord Denning says, and this is at page 142 of the decision, bear with me, I just want to make sure it's Lord Denning's. Yes.
And is it in the compendium?
Yes, it's compendium tab 17.
Thank you.
Page 142. I just want to read what Lord Denning says. So in the compendium tab 17, page 142, in the middle of the page, yellow highlighted, Lord Denning says, as a result of this important constitutional change, I am of the opinion that those obligations which were previously binding on the Crown Simpliciter are now to be treated as divided. They are to be applied to the dominion or province or territory to which they relate and confined to it. Thus, the obligations to which the Crown bound itself in the Royal Proclamation of 1763 are now to be confined to the territories to which they related and binding only on the Crown in respect of those territories. And the treaties by which the Crown bound itself in 1875, I guess they were referring to 1875 treaties, are to be confined to those territories and binding on the Crown only in respect of those territories. None of them is any longer binding on the Crown in respect of the United Kingdom. Now, that makes some good common sense. We run into a little bit of a problem if we start trying to look to section 109 and 111 and 112 and for an answer. We don't need to go that far. We just need to ask the question, given the constitutional obligation of diligent and purposeful fulfillment by the Crown, which Crown has the ability to make good on that promise? Now, at paragraph 58 of their reply, Ontario argues that because Ontario doesn't pay the annuities under Treaty 3, and they make the observation that in 1910, Canada claimed an indemnity, as one might have expected Canada to claim an indemnity, because let's go back. Remember, the whole dispute about Treaty 3 erupted with the St. Catharines milling case and the reserve creation there, and who could authorize the cutting of trees on the reserve, and who got the benefit of that. Incidentally, that led Canada to understandably in 1910 say, well, wait a second, we lost in the Privy Council, and if the underlying title belongs to the Crown, but Ontario gets the benefit, we, Canada, should get indemnified. Now, respectfully, what Ontario confuses is indemnity provisions with direct liability. We say they have direct liability to us, and it matters not that Canada might not have indemnity rights against Ontario. Whatever might happen as between the Crowns is no answer to the plaintiffs, who quite properly say, as the Privy Council observed, and as the Supreme Court of Canada observed in Grassy Narrows, The bargain was with the Crown. I do understand that you will hear from Ontario.
I just have a question.
Yeah.
If you say Grassy Narrow stands for the proposition that the Crown with the capacity, what is it? The Crown,
Jurisdictional capacity
the
is it
jurisdictional
good enough?
capacity
Yeah.
has the liability.
Has the obligation to
Has the
fulfill it. Yes.
obligation.
Yes.
With jurisdictional authority comes obligation.
Yes.
Now you say, but the bargain, it seems to me you're saying, if I understand this correctly, the bargain was with the Crown.
Yes.
And that suggests with a single Crown.
Yeah. No.
But then you said they were both there.
From the Anishinaabe perspective, it shouldn't matter to them at all. The promise, it should be assured to them regardless of the Constitution division of powers. But in terms of who is directly liable now to the plaintiffs for fulfilling the treaty obligation, well, both are, because both have the jurisdictional capacity to do that. Both have the jurisdictional capacity to sit down and engage in a process. Both have the ability to pay. And what Canada does not have the ability to disclose information about Ontario's use of resources, that would have to come from Ontario. But the obligation to disclose information is a separate obligation than the payment obligation. It is a separate obligation that the plaintiffs don't need. The plaintiffs need both Crowns to fulfill the obligation. They need both Crowns to share information. They need both Crowns to sit down and discuss and try to seek agreement as to what the appropriate net Crown resource-based revenues are in a particular period. But the fact that both have the ability to pay is enough for the plaintiffs. If one doesn't pay, we should have rights against the other. And we say, let the Crowns fight it out amongst themselves, but we don't want to be involved in that fight. We simply want to have our treaty rights honored and payment made by the Crown. And if for whatever reason it is more expedient to look to Canada to enforce that payment, we would do so. If it's more expedient to look to Ontario for that payment, we would do so. But as between the ultimate division between the Crowns, it should not matter to us, and we would let the Crowns happily proceed on with 25 to 35 years of legal wrangling as they did from 1873 to 1900, so long as my clients' rights are not negatively affected. Now, I'll just wait for you to catch up for a moment.
Thank you.
At paragraph 58 of their reply, I already made the point that about the indemnity and
Ontario's?
no, yes, I just wanted to make sure you got the point about the indemnity at paragraph 58. Remember, I had said that Ontario was confusing direct obligations to my clients with an indemnity provision. So now there's an issue that I want to address about the existence of Ontario. I say it really doesn't matter right? Because I say the proper test is not who was in existence, who was privy to the agreement. I say that doesn't matter. But I do think that this is an important constitutional case for Canada, and your decision is going to be important. And I do think it's important to get it right on this issue. So Ontario, at paragraph 47, at page 18 and footnote 90 and 91 of their reply, they argue that they shouldn't be liable because Ontario only came into existence in 1867, and the late United Provinces of Canada ceased to exist as that confederation. Our first point is that's just irrelevant because the proper test is in Grassy Narrows. But even if you wanted to go down the inquiry of when did Ontario come into existence, when did Canada come into existence, we say that their first proposition that Ontario only came into existence in 1867 is just wrong. We're going to explain why. And the second proposition that the old province of Canada no longer exists is an irrelevant proposition. We addressed this at paragraph 579 of our main argument, where we explained why that it doesn't matter for the purposes of direct liability whether Ontario only came into existence in 1867 or not. But let's address the issue. The court will recall, firstly, that Ontario's historical expert, Mr. Coates, was, to my recollection, careful in his wording, and I do not recall him suggesting that the 1867 Act of Union, which is another way to describe the Confederation Act, the Act of Union, was anything but that, an Act of Union. Secondly, the case cited by Ontario in support of the proposition that Ontario only came into existence in 1867 is the 1927 tiny schools case, tiny separate schools case. That tiny separate schools case is an important case, but the point they are trying to make, or Ontario is trying to make, is not actually supported in the case itself. And I think if we can go to tab 19 of my material, tab 18 of my material, excuse me, what I've done is I've excerpted portions of the decision. And it's a very, very lengthy decision dealing with the rights of Francophones to separate school funding, an important case. And the case was not tiny. Well, the case was the tiny case, but the length of the case was not tiny, and the subject matter was neither tiny either.
I believe it's a township in Northern Ontario.
Oh, okay. Yes. But the case was an important one. And Ontario points to page 657 of the decision to establish that the province of Canada, the province of Ontario only came into existence in 1867. But really, the passage moots a lower court decision that Justice Anglin for the court actually rejects. So let's read together what page 657 Justice Anglin for the court says. I haven't highlighted this portion, but it's in the first major paragraph, starting with, it was held by Rose J.
Got it, thank you.
It was held by Rose J. with the approval of the Appellate Division Court that because the rights or privileges of the separate schools at Confederation in regard to legislative money grants depended on legislation of the former province of Canada, and such grants were therein described as the fund annually granted by the legislature of this province in italics to highlight the point, and all other public grants, investments, and allotments for common school purposes now made or hereafter to be made by the province, again in italics, the province of Ontario, comma, newly created in 1867, was unaffected by any obligation in regard thereto. Goes on. About 10 lines down, the point is made by Justice Anglin. If that point that is raised would result in the protection of, this is the bottom of that very paragraph, would result in the protection of such rights and privileges afforded by subsection 1 of 93 becomes illusory, and the purpose of the imperial legislation is subverted. So far from agreeing that Ontario was off the hook because it was newly created, the court is saying Ontario is still on the hook. But what did the court mean by, did it really mean something important by saying it was newly created? And Justice Anglin returns to the so-called creation of Ontario at page 681 of the same decision, which I would ask you to return to. And this part was not cited by Ontario.
Sorry,
681 of the decision, page 161 of the compendium, tab 18. 10 lines down from the top of the page, the line starts with the word respondent, and the judge says this, referring to the 1863 Act, Separate Schools Act. Those terms meant after 1867, the new province of Ontario, which, as erected by Section 6 of the BNA Act, comprises that part of the province of Canada which had, prior to 1841, constituted the province of Upper Canada, and to which alone the Common Schools Act and the Separate Schools Act applied. What he is telling us in that passage is, although we call it the new province of Ontario, it's really just a separation, a severance of the old province of Canada into the entities that continue to exist, which will now be called Upper Canada and Lower Canada, which will now be called Ontario and Quebec. Now, the wording of the BNA Act actually leaves little doubt of this. And over on tab 19, I've excerpted paragraphs 3 to 6 of the Constitution Act 1867. And let's take a look at paragraph 3. It's under the heading Union. And the idea is, it shall be lawful for the Queen by and with the advice of Her Majesty's most honorable Privy Council to declare by proclamation that on and after a day therein appointed, not being more than 6 months after the passing of this act, the provinces of Canada, Nova Scotia, and New Brunswick shall form and be one dominion under the name of Canada. And on and after that day, those 3 provinces shall form and be one dominion under that name accordingly. So what you have is actually a union of existing colonies. Paragraph 5 then identifies Canada shall be divided into 4 provinces, namely Ontario, Quebec, Nova Scotia, and New Brunswick. Paragraph 6 helps explain how it is that from 3 colonies, you end up with 4 provinces. And what it says at paragraph 6 is, the parts of the province of Canada, as it exists at the passing of this act, which formerly constituted respectively the provinces of Upper Canada and Lower Canada, shall be deemed to be severed and shall form 2 separate provinces. The part which formerly constituted the province of Upper Canada shall constitute the province of Ontario. So to suggest that province of Ontario only came into existence in 1867 is actually just wrong. It existed since at least 1841, and it is now called the province of Canada. On this, I would like to leave the last words to Lord Watson in the 1896 annuities case. And I've got actually, we can go right to it, and it's in my main argument, footnote 390. I hadn't intended to actually cite this portion of it. I cited the whole paragraph 8, and the underlined portion was the part I was initially intending to rely on. But let's take a look at the first part of what Lord Watson says at paragraph 8 of page 137 of my main argument. Lord Watson, in the annuities case, this treaty says, the Act of 1867, which created the federal government, repealed the Act of 1840 and restored the Upper and Lower Canadas to the condition of separate provinces under the titles of Ontario and Quebec, due provision being made, section 42, for the division between them, between Ontario and Quebec, and I suppose Canada, of the property and assets of the United Province, with the exception of certain items specified in the 4th schedule, which are still held by them jointly. So Ontario continues to exist. It existed as part of the province of Canada. It was involved in the promises made and continues to be involved in the promises as a privy, quite frankly, but that's neither here nor there, because the Imperial Crown, you could say, was privy as well, but Commonwealth common law relieves the Imperial Crown of a liability, so says Lord Denning. And the Grassy Narrows case and Lord Denning both explain why Canada, who was not a privy in 1850, could not have been a privy in 1850, is nonetheless responsible as well. I haven't gone through my argument on joint and several liability in huge detail. I've highlighted the points that I think are important to make. I don't resile from many of the arguments I made in my material. And unless there's any questions on the issue of joint and several liability, I would tend to move on. My last section that I want to deal with is concluding remarks. And I want to talk first about the proper compensation for a past award. I'm going to call this section the house that justice built. Now, it's important to understand that whether you call it compensation in equity, damages in common law, or a just amount to vindicate a sui generis treaty right, we're trying to get at the same fair and just number. And to pretend that there is certainty in the numbers is an illusion. I appreciate that in my summary, which of relief sought, I have articulated numbers to help, numbers, but I am not asking, and I do not expect the court to say, yes, Mr. Schachter, we agree with the components of those numbers. The numbers are not there to ask you to say, yes, that's correct. Yes, that percentage is correct. Yes, that's the amount of monies, net revenues that came from logging taxes, logging revenues. That's not the amount, Mr. Schachter. We don't accept, I'm not expecting precision. We had an economist, and we had economists, many of them, sift through 173 years of data to identify amounts to be included. The needed data that should have and could have been kept by the Crowns is simply not there to provide the precision that would be preferable, whether in equity or in common law or in sui generis considerations. It just wasn't there. But what the economic experts could do is not give us precision, but they could give us estimates based on facts. What Stiglitz and Hutchins did in their thoughtful work provides what I say are guideposts on the path to justice that can assist the court. I say that these guideposts that they have provided are similar to a solid foundation on which a house can be built. Think about this. When a foundation is poured, and if one knows the strength and what the foundation will support, a builder can get a fairly good idea of how big the house should be. The length and width of the foundation will tell him how many square feet each floor can be. There's a boundary, and the type of foundation will help dictate how high the builder can build. So in this case, the credible and reliable evidence of Professor Stiglitz and Mr. Hutchins that we ask you to accept and prefer provides to the court important guideposts. One, their opinions, findings, and conclusions on direct NCRRs and indirect capture and rents and wealth deprivations are conservative, not extravagant. So that's a guidepost. Secondly, even their average 7.2% rate that they used, remember it's a nominal rate of return, is essentially conservative. Remember, long-term investors who save for future generations actually, this is what the evidence held, actually bears little risk in investing in equities. You might remember the evidence about the coin toss. If you toss the coin 1,000 times, there's really a certainty it's going to come up 50% of the time, and the risk of it is removed. You know generally what the outcome is going to be. And I believe one expert even testified that 100% in equities would be appropriate for that particular individual. But a 60-40 blend, 40% in conservative bonds and only 60% in equities. That's pretty conservative in and of itself for a long-term investor like the Anishinaabe are and were. Remember also that the 7.2% nominal rate, when average inflation over the whole time period is 3.57% as per Booth and Kirshner, we saw that yesterday, provides an average real rate of return of 3.73. Now, I'm going to stop for a moment because using these average numbers only gives you an indication. It's not mathematical certainty, because when you use averages, depending on, of course, in 1923, there may have been more revenue coming in that year, and the inflation rate may have been different. We're only looking for guideposts. We're not looking for mathematical precision. But if you deduct the average rate of inflation of 3.57 from a nominal rate of 7.2, you get a real rate of return of 3.73. Now, a real rate of return of 3.73 over time is far below the 5.01% rate of return that even Ontario argues in their material is the opportunity cost that was lost to the Anishinaabe. And that 3.73% is far below the real rates of return of 5 to 6% that anybody in 1850 would have really reasonably expected to pay if they reneged on a bargain when that treaty bargain was made. From the perspective of the Crown, not, of course, we don't take the position that the Anishinaabe were looking at interest rates in 1850 when they made the treaty, but if you ask the question, if there was an individual who entered into a bargain in 1850, what real rate of interest would they think they would have to pay if there was an amount to pay? The answer is 5 to 6%. Remember, it was Ontario's evidence in stage one, that there was no repeated and persistent inflation until well into, for a number of decades. Yes. We should add that the Eric Angel's evidence showed that Michipicoten by 1861 was in fact investing in municipal bonds at, I believe, 6% was the evidence. Thirdly, we know now from the evidence that if the court wanted to address the historic wrong by reference to the deprivations suffered by the Anishinaabe, by my clients, by the Robinson Superior Treaty Anishinaabe, that number is somewhere in the range of 153 to 193 billion. Again, that's 60-40, but I just want to sort of stay with apples to apples. We are not asking for that. We know as well that—
Sorry, this might be a time for me to ask something I should
yes.
have asked earlier. I think Canada either directly addresses this or alludes to it, that looking at the wealth gap or the income gap or the deprivation suffered by the Anishinaabe can't solely be attributable to the non-performance of the treaty promise, but comes from, and then I can't remember what they say, whether they say all instruments of colonialism or something, or the effects of the Indian Act, or the various steps or conduct by governments that have put the Anishinaabe and other Indigenous peoples of Canada in a position where, among other things, they ended up with huge income gaps.
So that is saying that.
But they finish by saying, and there are other mechanisms to recover as a result, or flowing from those different actions.
First point, remember these are guideposts. They're not set amounts. Remember that if Canada is, or Ontario is arguing that we did other illegal things, so you should relieve us, give us credit for the other illegal, wrongful things we've done.
I don't think they said illegal.
I'm saying it, okay? If Canada is saying you should go easy on us because we've done wrong things in other ways too. We didn't just cheat them out of their annuity augmentation. We did other wrong things to them. And so we get credit for that. That would be wrong in law. I can't, what is it? There's some principle of law that says you can't benefit from your wrongful conduct, or you shouldn't. The next point is, I think the court has to remember that this disparity is a disparity that existed, was shown to exist, notwithstanding all the government programs that existed, both benefiting Aboriginal and non-Aboriginal people. So it took the real world as it was. So Canada can't say there's, to say there's other programs for this. Those other programs were in place for the last 173 years, whatever they were. And we are not asking that the award correct the deprivation, because if we were, we'd be asking for 153 to 193. The Court of Appeal said it was important to look at this. We've now looked at it. It makes some sense to look at it because the Anishinaabe kind of looked at the promise as an outcome kind of promise. And so it is, as I say, a guidepost, a litmus test. It is not asking we are asking in this case for the loss of the annuity, the loss of opportunity to engage in a process to cause what could have been the annuity to be paid. So I just wanted to indicate that the deprivation is one guidepost. The next guidepost is, we know that there is an optimal amount of resource rents that Professor Bodway opined properly captures the value of the treaty territory. Now, on a wait and see approach, we know, of course, from the bar chart that we saw, Exhibit 35.1, that it's some amount greater than $126.3 billion. We don't know how much. But again, in that sense, if it's true that what the Anishinaabe brought to the table is the value of the treaty territory, then what they brought to the table is not 126.3 billion, but according to Professor Bodway, something more. Third guidepost, or next guidepost, excuse me. I'm actually up to number 5. We know that based on what actually happened in the real world in the past, based on Stiglitz and Hutchings' analysis, there was, again, using the 60/40, $126.3 billion of resource rents available to be captured by the Crown, who would, in a perfect world, try and capture that. We know, next point, that of that 126.3 billion, the Crown captured about 77 billion directly and indirectly combined. Secondly, we know that of that 77 or so billion, the Crown actually captured 56.895 billion, according to Stiglitz and Hutchings. by way of direct NCRRs. We also know from various charts and evidence that resource rents, whomever captures them, is actually a minuscule portion of the overall revenues that the Crowns receive from other sources unrelated to the natural resources and the use of lands and waters in the territory. So what all of these numbers and information tells us is, and what the court should be informed by, is that the proper quantification for past losses should be some portion of 77 billion actually captured, some additional portion over and above the 77 billion up to 126.3 billion total resource rents that could have been captured, or which the Crown, like Mr. Carney's 1858 suggestion, could have been considered as being captured even though they weren't. Knowing, and this court should know, that even if you included all of the 126.3 billion, you would still not be addressing all of the deprivations suffered. Please keep in mind, there is no set percentages we're advocating for. We have tried to identify for the purpose of helping the court with guideposts. There's no precise number, but there are parameters, there are guideposts. And we hope in our evidence, we have provided those reasonable parameters that the court can rely upon. We are not asking for and do not think the court can break down its answer into precise amounts or precise percentages. The court, for example, might ultimately think, well, I have a sense, says the court, from all the evidence I have heard, what is fair and just. I know it is within these parameters, and I could describe it as 84% of some figure, or I could describe it as 58% of another figure. But the important point for the court is not percentages. It's not trying to add up individual components of, I accept this particular category of resource was included. I accept this particular dollar amount for logging. What it's required is, because there is no precise math, it would be an illusion to pretend that there is precision in what the court is being asked to do. That doesn't mean the court can just choose any number it wants. The evidence you heard and the parameters I've given you provides a path to a solution, a path to a just award, and a path to reconciliation for the past losses. Now, because we do not ask for precision in numbers, I think the court should be, I guess maybe the court will want to hear from the defendants on whether they think the court requires precision, because I think it's not necessary, and I would hope my friends are of the same view.
Well, we know Canada is.
Pardon?
You know Canada's position on that.
Yes, yes. The final point I wanted to discuss briefly is looking at my Appendix A.
Could I just go to one question? I could look this up on my own, or I could check it with you.
Yeah.
Talking about the range of 77 billion to 126 billion, and you say of the 77 of which
Well,
of which 56.9 million was directly captured. Is it million or billion?
no, billion. If I said million, I misspoke.
Got it. Thank you.
And all of these numbers you might recall, or you'll find in tab 4 of my compendium, trying with where you can find them in the evidence. I wanted to conclude, I think, by looking at tab 20 of my compendium, which is the relief requested. And again, the first place I want to start, when you look at this document, I know I have broken down the dollar amounts as if there is some certainty to them. There is not. Although I have identified the relief requested as though there's actual dollar amounts, it's ultimately, in my view, whether at common law, sui generis, or equity, an assessment of what is fair and just, similar ultimately to what the court did in Guerin. Now, in the relief I request, I do request a number of declarations about breaches. 3 important points. I want to make sure that the order identifies that there's been breach of failing to engage in a process and failing to pay the augmentations when due, that the defendant crowns be jointly and severally liable, and that neither crown lacks jurisdictional authority or capacity to make the payments of the annuity when it becomes due.
And you have just read from
Paragraph 1.
paragraph 1, the declaration.
Yeah. So those are the principal declarations I think that are appropriate. And then I get into the quantification of the loss, and I've already discussed how they should be calculated. And it's an assessment, not a mathematical certainty. But we do say that under all of the circumstances, an award of 126.3 billion would be fair and just. Now, in paragraph 2D, as in David, I have suggested that if the court needs to look at an interest rate on bring forward amounts from 2020, again, I'm not suggesting that the court really needs to go there. I mean, globally, the court can just say this is it. But if the court did want to go there, you would look at the date of the filing of the claim, and I believe it was filed in 2001, which would make in accordance with section 127 and following, the proper rate would be 6%. And we thought it would be appropriate for a post-judgment rate to be 6%. Now, I'm quite happy for the court to just globally say this is what it's going to be up to date of judgment. But if the court really wanted to refine it and say, here it is up to 2020 and up to date of judgment, it should be at a further 6%. Yeah, Ms. Lewis wants me to confirm that I have made the point that the experts only quantified the losses up to 2019. And of course, further on in the proposed relief, we talk about a process to calculate the stub period from 2019 to date of judgment or into the future. How should the monies be dispersed? Well, this is in accordance with the agreement among all the First Nations who are recognized as such as part of this litigation.
Oh, another question.
Yes.
Very banal question. In one of the sets of submissions, I'm not sure whose, there's reference to the group of 5. Is that in your mind for the on behalf of the plaintiffs? Is that characterization you're comfortable with?
Yes, I'm comfortable with the group of 5. It's Red Rock, White Sand,
Yes.
Gull Bay, Michipicoten, and Fort William. Those being, just so everyone knows, those are the First Nations that the Crowns recognize as treaty beneficiaries and who are treaty beneficiaries and claim to be treaty beneficiaries, as opposed to the group of 7 who may be treaty beneficiaries according to the Crown and who may have unextinguished Aboriginal title and who may adhere to the treaty in the future. Maybe they already are. Who knows how that'll come out? But Mr. Gover will be speaking to that for the group of 7.
Right. But just for vocabulary, really.
Yeah. Okay. So the point is, for the group of 5, we should just get our money. My clients should just get their money now. Shouldn't have to wait. The amounts determined as allocated to the group of 7 should be dealt with by further court or order. Now, future implementation, I think, is important here. And this is where you might recall during my submissions, I said deterrence comes into play. Now, I see that we're at 11:15. I probably have 5 minutes left to go. So I would just continue. What's required is concrete measures and concrete direction to encourage diligent and purposeful and timely fulfillment in the future. And the first thing for the future that we would ask for is the slight refinement to the extant judgment to include in airspace and spectrum expressly. I don't think I need to go into detail about that.
No, can you just tell me where you are, though, in the order?
Yes, I'm at paragraph 6 of my proposed relief requested.
Thank you.
At tab 20.
Thank you.
Now, at paragraph 7, I've asked for a declaration that it is the court and not the defendant Crowns who have the authority to determine what the future annuity augmentation amounts are from time to time in the event the parties are unable to come to agreement. It's a little bit odd that I'm requesting that because my position is the order already says that. But because the Crowns have refused to acknowledge what the order says, I'm actually asking for a direct confirmatory declaration, if you can call it that. I don't want there to be any doubt any longer, and I would like the court to ensure that the parties know that it is the court that makes the final decision. I then talk in paragraphs 8 and 9 about the court maintaining a supervisory role, and my suggestion was that it should be in a manner that would not require pleadings to be filed afresh.
Can I just go back to paragraph?
Yeah, yes.
You say this is the paragraph that addresses discretion that was addressed in the stage 1 order.
That's right.
Can you give me the paragraph reference? If you have it for the stage 1 order.
Yeah, let me go. It's a combination of 2 paragraphs. I'm just going to have to go to it just a moment. I covered this in my argument. It's paragraph 3A and 3C, I believe it was.
Thank you.
And one moment. 1B. Process adopted, yeah. So in 3A, the court, if necessary, to determine the amount of net revenues. And then 3C, failing agreement, the court in a future stage of the proceedings would decide. And of course, the positive obligation to pay if there is an obligation. There's a payment obligation here. Hold on. 1A, pursuant to the treaty, the Crown is obligated to increase. And 1B, Roman numeral 2, if there are sufficient Crown resource-based revenues to permit the Crown to pay an increased amount, is required to pay it. So if you take all of that together, especially 3A and 3C, you end up with the court as the guardians of the Constitution and all that it protects, having the proper authority and being the proper party, if you will, to have the promises honored. The court should have the determination on a correctness standard. This is not a matter of judicial review.
Well, isn't it usually the court in the moment that decides what the scope of review is?
No.
You end up before the court.
Sorry, the issue of
in 5 years or 10 years.
No. I think that would be wrong, because Ontario and Canada are arguing that all you can do, or all a court should do, is judicial review. Ontario says on a reasonableness standard. Canada might say in accordance with the honor of the Crown, as though it was a consultation obligation. And because we're talking about a treaty obligation, my point was and remains that it is for the court to decide, and that's what the order says. And you are declaring rights and providing guidance on what the parties need to address in the future. I don't want to be in a position in the future where the Ontario, for example, says, well, we've made a decision to not pay you an annuity, and we think it's a reasonable decision and we don't need to justify it. It's just a matter of judicial review. Let's go to the judge.
Well, what if they just give you the decision and you say, let's go to court?
If I go to court, I want to have in my back pocket, by way of, call it deterrence, call it encouragement for diligent fulfillment, to say, I'm going to go ask the judge if what you're doing is correct.
Right.
And
I'm just trying to play this forward.
Yeah.
And Canada or Ontario says this is a matter of judicial review.
Right.
So you will make your argument there.
I could make my argument there, but I shouldn't have to make it, because the court needs to make a decision today, not today, well, maybe tomorrow, or sorry, maybe in 2-3 weeks. Let's give you some time.
Should your friends have a chance to respond?
Yeah. After my friends respond, you'll make a decision, but the decision you make needs to have some teeth in it so that the parties can understand what their obligations are in the future and what they need to discuss in the engagement process. And that if it's uncertain as to whether or not there are concrete obligations, and whether the judge gets to decide what's right, or whether it's Ontario that gets to decide what's right, whether it's the fox in the hen house that gets to decide what's reasonable or not, you're setting up an engagement process that is going to fail.
I'm just wondering if you actually think that a trial judge is going to tell whomever is looking at this case again, whether in the trial court, in the divisional court, or in the court of appeal, that there is a standard of review predetermined by me at this stage?
Well, no, sorry. As part of this process, we are asking you to define that, or we've joined issue with the province as to what is the nature of the review under the treaty. We've joined issue with that. We want you to decide that. We want you to decide that the answer is correctness. It's the judge who makes the decision as a matter of treaty interpretation, not about some future case. We've joined issue on what the appropriate standard is. We've joined issue. We've argued that the court gets to decide. Ontario's argued you don't get to decide. So part of this process, you have to make the decision about who gets to decide on what the treaty annuity is. And that's an important part of this case. I didn't think it was going to be that important before I read their material. But when I read their material, I am left with an empty shell of a promise for my clients if it turns out to be that the court can only engage in questions of, is it reasonable in a judicial review, administrative law, judicial review sense? I don't want the outcome of this case to turn a treaty right into a public law right of judicial review. So that's why I say, like the judge in Yahé, we need concrete measures so that the Crown understands what its obligations are, and we don't have a merry-go-round of future disputes about what the standard, who gets to decide the critical issue of what are the productions of the territory, what are the net Crown resource revenues. That's an objective question by virtue of the treaty that the court is properly to decide, not the Crown's. And so somewhere in your decision, we are looking for clarity on that point. The next point is keeping track and sharing of data. And we make reference to, because of our clients' abiding interest and the effect that exploitation, the degree to which resources are exploited in the treaty territory matters to our clients, we are not asking for an order that the engagement process will result in co-management. We are saying it should be a topic that the parties discuss. And this is one of those things that is an encouragement by the court, not an order to come to a conclusion, but an encouragement for the parties to discuss. And because I have hope that if the court adopts the Stiglitz and Hutchings model for the past, and if the court were to say, until there's agreement otherwise, let's just stick with that certainty. If we use that default formula for sharing, that would serve as an encouragement to meaningful discussions about the future. And if the Crown, in the future, believes that the Stiglitz and Hutchings methodology is somehow wrong, they would be free to return to the court, as we would be. Final points are there should be, I don't want to call it penal, because and that might be too strong of a word, but if they don't pay on time, what's sauce for the goose is sauce for the gander kind of thing. I'm thinking, if the government of Canada, when it needs revenue, doesn't get its revenue, it charges interest at a very hefty Canada Revenue Agency rate to taxpayers who don't pay their bills. And we have a situation here where we have an Aboriginal government, a people. And you know what? If the Crowns aren't going to pay their fair share, let them pay by what they say other taxpayers should pay. Sauce for the goose is sauce for the gander. As for costs, we would simply ask that we be permitted to speak to that following the release of your decision, which, as we had said at the outset, we hope is a speedy one and need not await anything that might happen in any appeal. Unless there's any further questions or comments from the bench, anything I can clarify for the court, that would conclude my submissions.
Thank you very much.
I think now would be a good time to break, obviously, and thank you to the reporter for hanging in there with me. It's 11:30. What would suit the court?
15 minutes.
15 minutes, and I plan. The group of 7 is going to move up front to.
Is that enough time?
Yeah.
Yes.
Order all rise.
Court is stood down for 15 minutes. This court is resumed. Please be seated.
Good morning, Your Honor.
Morning. Let me just put your material before me.
All right. Thank you. May it please the court, together with my colleague Spencer Bass, I have the privilege of acting for the added party plaintiffs, Bigdegong Nishnabeg First Nation, also known as Bigdegong Anishinaabe First Nation, or the Ojibways of Pick River First Nation, Netmesagamig Nishnabeg First Nation, also known as Pick Mobert First Nation, Pace Platte First Nation, Long Lake Number 58 First Nation, Bingwi Neashi Anishinaabeg, formerly known as Sand Point First Nation, Binjatawabik Zaging Anishinaabeg, formerly known as Rocky Bay First Nation, and Anibigu Zagagan Anishinaabeg First Nation. Collectively, we refer to those as the Group of 7. Now, while the members of the Group of 7 maintain they are not parties to the Robinson Superior Treaty because they were not represented at the Treaty Council and have not adhered to the treaty, this court and the Court of Appeal have recognized that they have a contingent interest in the outcome of this litigation. And with that preface in mind, I make the following observations about what the treaty entailed and the expectations of the Anishinaabe people in entering into it. By entering into the treaty, the parties made a solemn commitment. It was to share the value of the resources contained in the Anishinaabe people's traditional territories. The mechanism they chose to accomplish that goal was the annuity augmentation clause. Now, the Anishinaabe were giving up their exclusive control and access to their most valuable asset, the lands and waters of their traditional territories. The Anishinaabe had every reason to understand that the annuity would be increased in the future to provide them with a share of the wealth being extracted from their territory. That was the treaty promise. They expected that the Crown would reciprocate with a gift of commensurate value. The Anishinaabe expected the Crown to live up to the ideals of generosity and to fulfill its role as father in their long-standing metaphorical kinship relationship. And after all, as Mr. Schachter has pointed out, the Robinson Superior Treaty is a product of that kinship relationship, one that had existed for decades, perhaps a century before 1850. The Anishinaabe expected that the augmentation clause and the share of resource wealth that it promised would provide them and generations to come with the means to live their conception of the good life, Minnow B'Madzuin. But as we all know, the Crown failed to honor its solemn treaty promise. The result is that the wealth of the resources in the territory continues to enrich non-Indigenous Ontarians and others, while many Anishinaabe are living in abject poverty. Now, on behalf of the group of 7, I will be addressing 3 topics. First, common intention and the Anishinaabe perspective. Second, relative wealth disparities and the unequal distribution of the benefits of resource exploitation. And third, the inappropriateness of Canada's population sharing model. Mr. Bass will follow and make submissions on 3 further topics. He will submit first that Ontario's risk adjusting approach is unsupported. Second, that contrary to what both Canada and Ontario contend, equitable compensation principles are relevant. And third, properly calculating the present value must take into account the evidence and principles that he will describe. Mr. Bass will also address some procedural issues arising from the submissions of others, including those of the Name-Gusis-Agagan community. And Your Honor, we have prepared a compendium which has been distributed to the other parties and provided to Madam Registrar, and I would ask that it be received as Exhibit JJ, please.
Exhibit JJ, and I'll just take one moment to catch up. Thank you.
Thank you. With that, I will turn to the first of the 3 topics I will be addressing. That is common intention and the Anishinaabe perspective. And Your Honor, we dealt with this topic at paragraphs 17 through 104 of our primary written submissions. I start with reference to paragraph 290 of the Court of Appeals decision, which is in the compendium, and the tabs didn't find their way into the bound product, Your Honor, but we'll use page numbers if that's all right. This would be page 3 in the red numbering.
Thank you.
And that paragraph 290, of course, these are the reasons of Justices Lowers and Pardue. Said at the most obvious level, the concept of sharing was built into the augmentation clause. Any future increase in the annuities will be funded out of net Crown revenues from the ceded lands in excess of costs. In that simple sense, the revenues would be literally shared. In the words of Justices Lowers and Pardue, the Robinson Superior Treaty was, and I quote, an agreement to share in the value of the territory, end quote. And we have that in paragraph 293. Now, at paragraph 2B of the amended stage 1 judgment, appended to the Court of Appeals reasons, but not sadly reproduced in the compendium, I'd ask the court to note the language, and I quote, common intention that their agreement was to allow both the Anishinaabe and the Crown to realize the future opportunities and potential of the treaty territory in a manner consistent with the Anishinaabe principles of respect, responsibility, reciprocity, and renewal, and the intention of the Crown to act honorably with justice or fairness and with liberality or benevolence. I highlight those words: justice, fairness, liberality, and benevolence. And returning to the compendium at pages 5 and 6, and this is paragraph 323, where Justices Lowers and Pardue referred to first the treaty parties, quote, shared goals, expectations, and understandings, end quote, and second, the Crown's commitment to be liberal and just. Now, Mr. Schachter has already taken you to paragraph 323 of the Court of Appeals decision, but I take you there for a slightly different purpose. Of course, in paragraph 323, Justices Lowers and Pardue wrote, the court and the parties must return to the shared goals, expectations, and understandings of the parties in 1850, and based on those shared goals, expectations, and understandings, devise processes and procedures for the implementation of the treaty's promise in the modern era. The court continued, the parties in negotiations or the trial judge in stage 3 must determine the form, level, and aim of the sharing that the augmentation clause requires. The parties and the court should be led in doing so by the treaty parties' shared goals, expectations, and understandings in 1850, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal identified by the trial judge, and the Crown's commitment to being both liberal and just. Now, in my submission, Ontario's position in this litigation is hardly consistent with a commitment to being liberal and just. Let me take you, if I may, now to the kinship metaphors that are referred to in this court's stage 1 decision. This is in the compendium beginning at page 8. And in particular, paragraphs 44 to 47 at page 10. And I won't read each of the paragraphs, but there's some key language here that in my submission helps inform the Anishinaabe understanding of what the treaty promise was. And I know this is something that the court dealt with extensively in stage 1, but it bears emphasis at this point. Paragraph 43, the court alluded to the fictive kin relationship that had to be created to initiate a relationship in the absence of an actual kin relationship. Paragraph 44 involved a recognition that fictive kinship was established through trade, language, and intermarriage that proceeded in accordance with established Anishinaabe protocols in the region. This was a way of differentiating relatives from strangers. And importantly, in paragraph 45, the use of the terms great mother and great father. The point being that in use of a term like great father, the Anishinaabe did not conceive of the father as an authoritarian, but instead someone who was to provide for his children's wants and needs. And of course, the court pointed out in paragraph 46, European actors made reference to these kin metaphors in communications with the Anishinaabe. Colonial officials used them in indicating that they understood the moral obligations and duties that kin owed each other. And these principles were acknowledged by the Crown through its various officials. And the court in paragraph 47 referred to the state of affairs in 1850 when kinship metaphors were still very much relevant and defined the expectations, perspectives, and understandings of both the Crown and the Anishinaabe. Now I pause in relation to paragraph 45 and this concept of the great mother, the great father, the moral obligation. And returning to this point that the father was not, in the Anishinaabe worldview, an authoritative figure, but someone who was to provide for his children's wants and needs. And this calls back to mind Raymond Goodchild's evidence about the conversation he had with his father when Elder Goodchild came home from having served in the Canadian Forces not long before his father died. This is not in our compendium, it's in the transcript compendium, and the pages are pages 2440 to 2441. And with Mr. Bass's assistance, we have that on the screen now. And the question was asked, Elder Goodchild, you've told us about your start in life in Rossport. Did you ever speak to your father about that? Answer, in, I would say, 1984, 83, after I came back from the Army, right? Me and my dad sat down for supper. I believe that my dad knew he was going to leave the earth. He sat down and said to me, my son, I tried my best. I'm sorry I can't write. I'm sorry I can't keep a steady job. I'm sorry I didn't feed you, he said. I went to residential school, he said, St. Joe's. And I'm sorry all the hardships that you endured. Please forgive me. I looked at my dad. You tried your best, Dad. I understand what's going on in this world. I've seen it already. I've seen what goes on. And my dad, I love him to this day because he tried. He paid land tax. He paid school tax. He tried. He tried. Now, Your Honor, my point in referring to that moving evidence is that it vividly illustrates that in the Anishinaabe worldview, the father was to do what he could to provide for his children. The kinship metaphor and the elevation of the crown to the Great Father were consequential. They had meaning in 1850, and they must continue to have meaning today. And I say this, Elder Goodchild's father can be excused for failing his children, but the crown has no excuse for failing the Anishinaabe. Returning to this court stage 1 decision, which is in our compendium at page 11, the court dealt with the concept of gift giving in paragraphs 48 through 52. It was, paragraph 48, referred to as being ubiquitous among the Anishinaabe, considered an act of moral imperative. In paragraph 49, gifts were given in accordance with the principle of reciprocity, which holds that items of value are given with the expectation that the gift will be returned. Court concluded that paragraph with the sentence, the rule of gift giving was this: the closer the kin relationship between the people, the greater the reliance, and therefore the implication of trust. And reciprocity was dealt with also at paragraphs 419 and 420 of this court's stage 1 decision, which we'll have at pages 13 and 14 of the compendium. The point is that and this is paragraph 420, the Anishinaabe chiefs and leaders had every reason to expect that their gift attracted a reciprocal gift commensurate with the value of what they had provided. Now, you've heard from Mr. Schachter extensively about the value and how the evidence of Professor Stiglitz and Mr. Hutchings provides an important guidepost in understanding the value of the land, the value of the gift. And I want to focus on reciprocity and what it can tell us about the concept of economic rents. And let me say that on behalf of the group of 7, Mr. Bass and I adopt the submissions of Red Rock and White Sand about how you can use the evidence of economic rents that you received in this trial. The evidence of Professor Stiglitz and Mr. Hutchings was compelling. It was, in many respects, unchallenged. In many respects, uncontradicted. And at the end of the day, we submit, as Mr. Schachter does, that it provides an important guidepost to the court in its assessment of an appropriate compensatory award. We adopt and rely on every word you've heard on behalf of Red Rock and White Sand in that respect. But of course, we need to think about eventualities and the positions taken by others in this courtroom. And that leads me to a submission which is made in the alternative. And that is, if you are inclined to accept the position of Canada and Ontario, that the revenues to be shared in this case are only the direct net Crown resource revenues, stumpage fees, mining profit tax, water rental fees, etc. And my point here is that does not mean that the evidence of economic rents can be or should be discarded. It will remain an important guidepost. It will remain evidence that is relevant and important to your consideration. And that's because in my submission, at a minimum, the concept of economic rents serves as an important interpretive aid. And I think really that's what I'm saying in a way to echo what Mr. Schachter says. I say an important interpretive aid. Mr. Schachter calls it a guidepost. And in my submission, and hearkening back to the language of paragraph 323 of the Court of Appeals decision as spoken through Justices Lowers and Pardue, it is still relevant and must still be important to your determination of the form, level, and aim of the sharing that the augmentation clause requires. And in my submission, we are led to that conclusion because of how the concept of reciprocity informed the parties' common intention. In my submission, the evidence of economic rents assists us in understanding the value of what was given up by the Anishinaabe. To use Mr. Schachter's term, it provides the guidepost. And I say a crucially important guidepost. It assists us in understanding what the gift of commensurate value was that the Anishinaabe rightly expected in return. And so at an absolute minimum, and this is in that alternative argument, in the event that the court is inclined to accept the submissions of Canada and Ontario, which we submit it shouldn't, the evidence of economic rents should help inform answers to questions such as, on the revenue side of the ledger, what portion of the net Crown resource revenues should the Crown, acting honorably and diligently, share with their Anishinaabe treaty partners in the form of augmented annuities? And we say with respect, the answer to that question must be that it should be a generous share that accounts for the incredibly valuable gift that the Crown received. Again, I say interpretive aid, Mr. Schachter says guidepost. We are really saying the same thing. Well, here's the other question, really. On the expense side, what expenses should be included to account for the without incurring loss aspect of the augmentation clause? And this answer, or the answer to that question, must recognize that the Crown is receiving this enormous benefit in terms of the economic rents, both in terms of the indirect revenues that it is able to recapture, and in terms of the downstream benefits it is able to direct towards private actors to further its own policy goals.
I just might have a question on this. If I understand what you're saying, and maybe you're going to go further to help me, but let me ask it now. If I understand what you're saying, okay, so in the alternative, let's look at NCRRs. And NCRRs, I think, as defined by the defendants, or maybe defined commonly, are revenues directly received by the Crown. So you say, all right, in the alternative, let's look at NCRRs, but look at them, but then look at sharing through the lens of reciprocity.
I'm going more to the definition of the NCRRs. I'm going, and I say that using economic rents as an interpretive aid, it calls for a generous approach to be taken. So any close calls must go to the Anishinaabe. The Crown can't say, I'll come to the example of colonization roads, for example. They can't say, oh, well, some portion of railroads or colonization roads were used to exploit resources. That's the point really there. Not so much sharing, but
the narrow versus broad approach to expenses, for instance.
That's it, Your Honor, yes. And the point is that the Crown should not be able to devalue its reciprocal gift to the Anishinaabe by subtracting a broader range of expenses that support economic rents and other benefits generally. So just as, for example, and I've alluded to them, railroads, colonization roads, those are the tools of nation building, and it would be wrong to treat them as expenses, literally at the expense of the Anishinaabe. Relevant expenses should be confined to those that are truly connected to the revenues being shared. And I say that we must ensure that the Anishinaabe receive the reciprocity that they expected when they gave up something of such immense value to them. And of course, the Crown was obviously aware of the centrality of reciprocity in entering into the treaty because of its observance and participation in the Anishinaabe gift-giving practices in the century leading up to 1850. So you have my point then. In summary, the common intention to allow both the Crown and the Anishinaabe to realize the opportunities and potential of the treaty territory, consistent with the Anishinaabe principle of reciprocity, calls for a generous approach in determining net Crown resource revenues. And in stage 3, this court heard evidence about the importance of gift giving and reciprocity to the Anishinaabe people. This evidence bore out the expert opinion evidence of Dr. Dribbin that in the Anishinaabe perspective, quote, and by the way, this is in paragraph 35 of our main submissions, footnote 25, Your Honor. This is Dr. Dribbin. In the Anishinaabe perspective, quote, if you give a tremendous gift, you expect equal value, commensurate value for the gift in return, end quote. And that takes me to the evidence of the chiefs and elders, which is reproduced in the compendium. And I'll start with the evidence of Chief Mashano, which you can find in the compendium at pages 16 through 19. And in particular, I would take you to a portion, Your Honor, that begins toward the bottom of page 18. It's around line 24, where Chief Mashano said, and there's always that expectation that you do something for somebody, that they're going to do something for you at some point. He continued at line 5 on page 19, I think the way our people think is that, you know, nobody should be getting more than what other people get, your share. The testimony of Elder Donio is set out on this point at pages 21 through 26 of our compendium. And if I may, I will take you to page 23. And in particular, starting around line 8, you'll see there that Elder Donio said, the Anishinaabe gave access to the land. They expected something in return that would, in his words, and I quote, enable us in some way, individually or collectively, to attain a better degree of Minopamatuan, end quote. At pages 25 to 26, Elder Donio further testified about reciprocity in these terms. Starting at line 20. And they, and this is a reference to the Anishinaabe people, the leaders in 1850 especially, were led to believe that the sharing of wealth, whatever that was, and however it was intended, would come back to us. And that if, you know, we give that which is basically the essence of what we have to offer, our land and resources, we have nothing beyond that. Was there an expectation or hope that some of that might be reciprocated? Absolutely. And it wasn't just a hope, but it was statements that were made that caused people to believe. Statements like the Great White Father and the Great White Mother will look after you, means I'll be okay. I'll be looked after. We'll be looked after. Not just me, but our family, our community will be looked after. And Chief Tangi testified to similar effect. And with that, I take you to page 28 of our compendium. Chief Tangi said this, and it starts at line 3 at page 28. Our thought process as Indigenous people is if we're going to be giving our very best, then there should be a reciprocal relationship where who we're sharing with should be giving their very best as well. Because these gifts that we receive from Creator are our most sacred gifts, and the land and the resources are our most sacred. The point of that aspect of Chief Tangi's evidence is that the Anishinaabe gave their best. They should have received something of great value in return, and they were entitled to expect to receive something of great value in return. And that leads me to the point that this court has also heard evidence about, that to the Anishinaabe, the land was the most valuable resource.
I don't want to start anything that we can't get out of, but often the Anishinaabe witnesses in this stage and in other stages spoke less of the land as a valuable resource than as the land is part of us. We are part of the land. So I just, I worry about always reverting to the language of economists.
Which is a very fair comment. And undoubtedly, I can be guilty of seeing this through the lens of someone who is non-Indigenous. And I think that Your Honor has injected an important caveat in the treatment of this, where, of course, the focus of these submissions from me is about reciprocity and the value of the land. But, and I think that we need to keep the caveat that Your Honor has injected in mind. I think it goes to the value of the land, because this is the identity of the people of the land, as Chief Tangi put it. And of course, I don't want anything that I say in making these submissions to be taken as disrespectful to the Anishinaabe.
I didn't suggest.
No. I'm I may not be addressing you in saying that, Your Honor. Thank you. Elder Donio, at page 30 of the compendium, commented at line 15, to us it means that we will share what we have, and the greatest asset, if I can use that word, that we have to share is our land and resources.
There you go. I'm wrong.
I'm not about to agree with you about that, Your Honor.
So I'm just, as I go through this, your compendium, if I don't go back to the table of contents, you are telling me who the speaker is or who the witness is.
I am doing that.
So tab 5 is Chief Tangi and tab 6 is Elder Donio. So I can.
Yes, the table of contents identifies each speaker. Or where it's a reference to an article to the writer.
I've got it. Thanks.
Good. All right.
Okay.
Well, moving on then, Chief Machano testified to similar effect. We have this excerpt at page 33 of the compendium, starting at line 15. Anishinaabe people have a deep, deep connection to the land and the water because it sustained them for all those thousands of years, basically. And something I've already alluded to was the evidence of Chief Tangi. And this is at pages 36 through 38. I'll take you initially to page 36, at the top of the page. And this is in keeping pretty much with what Your Honor recalled. Chief Tangi said, as Anishinaabe, we are people of the land. The land is of the utmost importance. It was a gift that was given to us by Creator. And Chief Tangi, at the bottom of page 37, was asked to describe the gift of land from the Creator, line 25, and carrying over to page 38. It was our most sacred gift. It was our most sacred gift because everything that we need is from the land. And she continued on at line 15 on page 38. What we really need is to have land and resources that can sustain life. So you have my point. The court has before it a compelling body of evidence about the Anishinaabe principle of reciprocity, something already recognized by this court in stage 1 and by the Court of Appeal in its decision. And it has compelling evidence about the value of the land to the Anishinaabe. The court also has before it the evidence of a Nobel laureate about economic rents, which at a minimum serves as an interpretive aid, a guidepost, something that in our alternative argument calls for a generous approach to the determination of net crown resource revenues. Now, returning to the evidence of the chiefs and elders, the evidence on stage 3 also established that Minnow Bamadzawin is a unifying concept of Anishinaabe culture. This takes me back to the evidence of Chief Tangi, and this is reproduced starting at page 40 of the compendium. And I'll take you to page 41, line 2 Chief Tangi's words, that Minobimodzowan, that concept of Minobimodzowan is very real. It's very instilled in our hearts and in our minds. It always was, and it always will be for Indigenous people. At page 42, starting at line 3, Chief Tangi added, Minobimodzowan is a very real understanding of how to live a good life. And the court has before it as Exhibit 1-1567, the article by Lawrence Gross, Bimodzowan, or the good life as a unifying concept of Anishinaabe religion. And this will be at pages 44 to 45 of our compendium. And at the bottom of page 44 of the compendium, the moral structure of traditional Anishinaabe religion, as encapsulated by the term Bimodzowan, is at least one unifying concept, providing continuity in the worldview of the Anishinaabe from past into the modern era. Bimodzowan, or the good life, can basically be described as a long and healthy life. And that was the life goal for the old Anishinaabe. This was the subject of evidence from Elder Donio. And in particular, I would take you to page 47 of the compendium. Elder Donio explained that having material resources was an essential part of Minobimodzowan. And he said at pages 47 to 48, well, certainly material resources are an essential part of Minobimodzowan. You need a house, you need shelter, you need sustenance, you need basics, you need essential items that will enable you to do things, like get wood. You need a saw, you need an axe, you need a sled, you need a good dog team to pull your sled. So you need those kinds of physical items in order to, for you to continue to strive for Minobimodzowan, a good life or a better life. And this was particularly significant for us in our communities when we looked at some of the elderly, more elderly or infirm people who may not have been able to do those kinds of things for themselves. So we look at it, and I remember Dubbis. Recall he referred to his great-grandmother, I believe, saying to me, well, we should go and do this for so-and-so. And it was never something where I said, well, I don't want to go and do that for them. We just did it because the old lady recognized, knew something, knew people and said, those people need a hand with something. So we will go and do it. So we needed that. And he said at page 49, starting at line 6, doing those things enabled us to work toward Minobimodzowan. And at page 51, at line 7, well, the idea was always more because the focus was not just the here and now. It wasn't just today. There was always a focus as well on the future, on future generations. What are we going to do to make sure that our kids, and they're much the same as people today, what can I do to make sure that when my kids are going out, that it's easier for them than it was for me? And on this subject of material resources being necessary to achieve Minobimodzowan, I'd ask the court to take into account the evidence of Chief Mashano. And we have it reproduced in the compendium, pages 53 through 58. Chief Mashano testified that cultural activities of the Anishinaabe people in the context of Minobimodzowan include hunting and fishing and being on the land, and that the influx of the non-Indigenous settler population has resulted in competition for and depletion of fish and wildlife. Referring to the impact of the Anishinaabe of competition from non-Indigenous people, Chief Machano testified at page 56. And this is starting at line 14, Your Honor. So they had to go farther. They had to hunt harder. They needed new tools to do that. They said they needed steel traps. They needed steel knives. They needed axes, files, the whole bit, needles and awls to help dry your beaver skins. You needed all those things. Chief Machano testified, this is at page 57, so you always needed financial assistance basically to help you, and nowadays it's even more so. And that's starting at line 17 and carrying on through line 19. And Chief Machano then referred to the need for snowmobiles, all-terrain vehicles, boats, and nets, all of which require financial resources. And in my submission that it's clear that the metaphorical kinship relationship of parent-child informs the augmentation clause. And in that respect, I refer to Exhibit 14, the happiness report of Dr. Dribbin. We have it in the compendium at pages, excerpts of it at pages 60 to 61. And at page 60, Dr. Dribbin wrote, in their discussions with Robinson, the Anishinaabe used the term "my father" to formally acknowledge that they were depending on the Crown to act as a peacemaker, a protector, and a provider who was devoted to his children, tolerant of their mistakes, ready to assist them whenever and wherever possible, and willing to provide them with a full range of the necessaries and niceties of life in a way that was designed not to inhibit or discourage, but to enable them to acquire a meaningful cultural identity akin to their own. He continued, the Anishinaabe expected the Crown to act on their behalf in a manner that balanced authority with generosity and compassion, which is precisely what band members expected with respect to the implementation of the augmentation clause. Sure. Compassion, which is precisely what band members expected with respect to the implementation of the augmentation clause, whose financial niceties were beyond their understanding at the time. And Dr. Dribbin at page 61 further opined that the Anishinaabe employed the term "my father" to signify that in matters in which they placed their trust in the Crown, they expected the Crown to act on their behalf in a manner that balanced authority with generosity and compassion, and which is precisely, in his view, what band members expected with respect to the implementation of the augmentation clause. So with that, and subject to any questions, I turn to the second of the three areas that I'm addressing: relative wealth disparities and the unequal distribution of benefits of the resources. And I know we've been taking breaks somewhere around now. I'm content to go till 1 or beyond if the court sees fit, but I'm also happy to break now.
I'd like to break now, please. And we'll come back.
Thank you very much.
Thank you. 2 o'clock,
Thank you.
everyone.
Order all eyes.
Court is stood down until 2 p.m.